Good morning.
And on behalf of Mr. Jarmo, Attorney Sean.
This video shows a court hearing about a child custody dispute between a mother and a father. The mother is represented by attorney Miss Johnson, and the father is represented by attorney Sean Cox. What's happening? The mother filed a motion asking the court to officially decide who gets legal custody and to set a clear parenting schedule. The father, who moved away in 2016 without telling the court, now wants full custody and to change the child's school. Miss Johnson says this case needs to move forward quickly. Mr. Cox asks for 1 more week to respond properly to the mother's request. What the judge says. The judge understands both sides and agrees to hold a meeting next week to talk more about the case. In the meantime, the judge says the old custody and visitation plan will stay in place. The judge also says that it's better to have clear, legal custody instead of just informal agreements to avoid confusion. Legal custody means the right to make decisions about the child's life, like school, health, etc. Parents must tell the court if they change their address. Both lawyers are trying to work together to solve the issue fairly. The court wants to protect the child's routine and emotional well-being. Changes in where parents live or work can affect custody decisions. Changing the child's school must be decided carefully. Usually after custody is settled, a meeting is scheduled for next week to keep working on the case. The goal is to find the best arrangement for the child, quickly and fairly.
Sean Cox, good morning.
Good morning, Your Honor.
So I have read your motion, Ms. Johnson, and let me tell you what I know first, and then I'll turn to you. So this is kind of an interesting case because when this matter was filed, your client lived in Kentwood at the time it was filing, and now finds himself in a ways away here. And when did he move?
2016.
Okay.
Sorry, no, 2005.
When did he notify the court he was moving?
I do not believe he's notified the court. These parties really have been outside of court this entire case, and just kind of working things out. There's really been very little court involvement during this entire matter.
Okay, because the friend of the court in 2024 still had his address on Shoreside Drive in Grand Rapids. And isn't he under an obligation to let the court and the friend of the court know where he's hanging his hat?
He is, and we can have him update his address, of course, with friend of the court. Mom has known this whole time. I think he just probably didn't realize he needed to do that. And the result of that would be if she had filed motions, he simply would not have gotten notice, most likely.
That's my concern. Because he now lives in Bellevue, isn't it?
That's correct. He's lived there. He said he believes around 2016 he's been there.
Oh, okay. So I read your motion. Anything you want to add to it before we hear from Mr. Cox?
I'll just state our request for relief, again, for the record. There has never been a legal custody determination, so my client would like that. He would also like a specific parenting time order, as there is not a specific parenting time order, and parenting time agreements have broken down. Mom has physical custody pursuant to the judgment of paternity that was entered at the end of 2015. As we've stated in our motion, there are several facts that support proper cause or change of circumstances to review physical custody. My client is asking for primary physical custody, but certainly we believe that even joint physical custody has been the status quo in this case. So he'd like physical custody reviewed, and he does have a school change request also.
Doesn't he have to wait until he has legal custody to make a school change request?
Your Honor, I think technically that would be right, but we put it all in one motion for judicial economy. I don't, in this case.
All about that.
Mhm.
I'm all about judicial autonomy. Mr. Cox, your thoughts, please.
Thank you, Your Honor. I just want to indicate to the court that my client was properly served, Your Honor. She did receive these pleadings by mail on Saturday, last Saturday. She was able to retain me late Tuesday afternoon. I wanted to file an appearance, but I did not want to file kind of a C- response in a hurry to a large motion. So I did contact Ms. Johnson requesting an adjournment. She denied that request, and I'm not crying about that. I understand why she denied it. She's concerned that the next motion date was not available until the 25th, I believe. So I certainly have empathy for her position in that regard, Your Honor. But I'll cut to the chase. I'm simply asking the court for 7 days or 1 week to file a legitimate response to the motion. Certainly, Vodvarka will loom large, but with that said, again, trying to have empathy for the other side here and understanding that the next available motion day is a few weeks off. I'm not sure how to handle that. I'm trying to maybe meet in the middle somehow, Your Honor, but I just would like an opportunity to file a legitimate response from my client that I just did not have the time to do that. And so if the court would allow me that, I'm willing to, listen to whatever we can do to address that. I know that Your Honor is extremely accessible to all of us as attorneys. I don't know if perhaps we could handle this in a case conference. I know your schedule is very tight, Your Honor. I know that. So I don't want to be presumptuous on that front, but I'm ultimately, at the end of the day, I'm just asking the court for a week to respond appropriately and to try to get this case moving forward without being disrespectful of Ms. Johnson's desire to move the case forward for her client. And that's what I'm asking the court to consider this morning, Your Honor. Thank you.
Thank you. Ms. Johnson, what are your thoughts about, I get it. I think we've got things going on, so it's going to be a while, but I could probably accommodate a case conference next week. Is that feasible?
I likely would be available for a case conference next week, but I think some of the undisputed facts here give rise to proper cause or change of circumstances.
Maybe.
Primarily just the undisputed parenting time that the parents voluntarily started exercising when the child entered kindergarten, when he was, or right before that, when he was around 4 years old, where my client was getting every Wednesday and Thursday overnight.
No, I can address that, Ms. Johnson. I can address that. What I want you to do, I will, Mr. Cox has always been an honest broker with me. I will give him an opportunity, and I understand Ms. Johnson's position too. You both can contact Ms. Bolin next week, Monday, and I will accommodate a case conference and hear all this out next week, based on your schedules. One of the things that I will both tell you is the whole notion.
I hope you have learned something from this court hearing, and thank you for watching. Don't forget to subscribe for more interesting content.
And I get your point, Ms. Johnson, that legal custody was not judicially determined. That's an interesting extension of Sims versus Verbrugge, because Sims versus Verbrugge really involved a judicial determination versus an affidavit of parentage, and this was a paternity case. So there are some that would say that that doesn't apply, but I think the mere fact that the parties have moved and time has gone on would probably provide that proper cause or change of circumstance, but I'll leave that to next week when we discuss that. But I will tell you, Mr. Cox, that I expect, while whatever the outcome is, if the parties have been exercising an agreed upon interim schedule that's contained in paragraph 5 of Ms. Johnson's motion, I expect that to be followed. And if that means reinstalling Wednesday, so be it, until we meet again. Because I don't want this case to get away from everybody in that respect. So if you want to contact Ms. Boland on Monday, but my intention is to, unless I'm told why it shouldn't happen, my intention is, whatever I do, is to reinstate that interim schedule that's in paragraph 5 of Ms. Johnson's motion, but I can be convinced otherwise if there's a reasonable cause to do that. So I will see you all next week, and we're adjourned. Thank you.
Understood. Thank you very much, Your Honor.
Thank you.